So the case is called Actavis against Lilly. It concerns a patent that Lilly owns on pemetrexed disodium in combination with vitamin B12, which is a patent protecting its commercial product, which is called Alimta, which is an anti-tumour agent. And in this case, Actavis have a generic version of pemetrexed, which is actually a different salt called pemetrexed dipotassium, and there were some other salts as well, which they want to launch in a number of European countries, but first wanted to clear the way, essentially, of any potential locking issues with the Eli Lilly patent. In order to clear the way of the market so that it could market its own generic, Actavis had to bring a non-infringement declaration claim. That is, it's asking the court to say your product doesn't infringe the patent owned by Eli Lilly. The unusual thing about this case, in fact the unique thing about this case at this stage, is that the claim was not just for a declaration of non-infringement in the UK, it was also for a declaration of non-infringement from a UK judge in Italy, Spain, Germany and France too. Well, this Actavis case follows on fairly closely after a completely unrelated decision by the UK Supreme Court relating to copyright and some design aspects of the stormtrooper helmets from the Star Wars films. In that case, the UK Supreme Court said that providing the defendant is non-domiciled in the EU and providing validity of the intellectual property right is not raised, the UK court has a jurisdiction to decide on foreign intellectual property rights. In the UK, Actavis was successful in getting a declaration for the UK, France, Italy and Spain, but the Germans, by the time the judge came to decide on the German part of the case, the German courts had already decided in a parallel action, and in that action the German court had decided that it didn't accept jurisdiction of the UK court because the parties were different in the German action to the UK action. J actually stipulated that the reasons it thought it had come to a different decision was that it applied a different construction test. It didn't adopt, as the UK never does, the doctrine of equivalence. The German court does adopt that doctrine. But also in the UK court, the judge said he had heard different evidence. The evidence had taken on a different complexion under cross-examination in the UK to Germany, and also in Germany the prosecution history of the patent in question was also influential on the judge's decision. Again, in Germany that was never considered. All of these things added up to the different decision that the UK court came to. It was something of a surprise to UK lawyers because it's always been said that there is no what's called file wrapper estoppel doctrine in the UK, and I think that still technically is a position, but the judge said nonetheless there was nothing to say that what had happened in the prosecution of the patent in the EPO couldn't be an influence on this decision. The big question is whether this has really opened up the way for similar related actions. It seems quite likely that there will be further cases asking for these cross-border non-infringement declarations. The limitation, as I said before, is that the defendant has to be a non-EU resident defendant or domicile defendant, and also validity can't be raised in the case. So it has to be a pure declaration of non-infringement action. It is going to be a new tactic for those who are wanting to clear the way of blocking patents so that they can launch, in particular, generic products that might otherwise be blocked. And because it's cross-border, it's potentially a powerful route to clear the way in a number of countries. But one thing remains to be seen, and the success of this as a tactic depends on this, is how countries such as Italy and Spain will react to these decisions, and whether in fact they will be prepared to recognise them and enforce them in those countries. As Germany has already illustrated, they might not necessarily do that. The decision of Arnold J is typically a very long decision, very, very thorough, a fantastic analysis of the law, and something of a masterclass on quite a number of issues, and something that lawyers like myself will digest for some time to come.